Legal Pond.
Welcome to today's episode of the Legal Pond. If this is your first time visiting this channel, kindly subscribe to the channel and click on the notification button so that you'll be notified as and when we upload new videos. Today's video is going to explain what is an offer, what an offer is. Let us get started. Welcome back. As I said early on, today we are going to look at what is an offer and the various technicalities regarding an offer. We remember from our previous lesson that for a contract to be formed or for an agreement to graduate from a mere agreement into a contract, there must be certain elements available. And those elements includes an offer, acceptance, consideration, intention to create legal relations, capacity to contract. So we are picking the first one, which is an offer. Now, what is an offer? Before I go into that, you notice very well that at a point in time where the parties wants to enter into any form of agreement or a contract, the parties talk a lot. They engage in negotiations. And then you realize very well that some of the statements that they make, the parties, it may mean they are making an offer, but in reality, they do not qualify as an offer. So you look at a case like Gibson versus Manchester City Council, which was decided in 1979. You notice very well that when the City Council sent the letter to the plaintiff in this case, the plaintiff in his mind thought they were making an offer to him. When you compare that with the case of Edu and others versus Attorney General and others, the letter that was sent to the plaintiff in this case was clear. So in the minds of the state, when the state wrote to the person that they wanted to give the estate to the tenants who were residing in that estate at Kanda, the state thought they were just making a mere invitation to treat, not knowing they were making an offer. So the question is that what at all is an offer? Because there's a conflict as to what is an offer and what is an invitation to treat. So what is an offer? We are very lucky to have a very standard definition given by Lord Justice Dateba in the case of NTAC versus Ya Entry, where he said, when we say an offer is an indication in words or by conduct made by an offeror that he is prepared to be bound by a contract in the terms of the offer, if the offeror communicates his acceptance thereto. So I have paraphrased what he said in my own language. Remember, in exams, no one expects you to write the law as it was written in the case, but you are expected as a student to communicate the idea that the authority communicated. You are not expected to, for instance, you want to quote Article 10 of the Constitution. You are not expected to quote it as it is. You are expected to communicate the idea there. The same thing applies to principles in cases. So I'm taking it again. He said, when we say an offer, it is an indication in words or by conduct by the offeror that he is prepared, he is ready to be bound by a contract in the terms of the offer, if the offeror communicates his acceptance to that offer. Then the judge went ahead to give certain characteristics of an offer, certain things that when we see, we can conclude that this is an offer and it can be differentiated from other things. He said for something to be an offer, first of all, it must be final. 2, it must be definite. And 3, it must leave no significant terms opened for further negotiations. So if what you have given is not complete, such that I would have to ask certain questions for it to be complete, then it doesn't qualify as an offer. So when you look at it in light of the NTHC case, where the company wrote a letter to the woman indicating that they wanted to sell some of their properties to their workers. The woman received the letter. The letter had the specific property they want to sell, the location, the price, and every important information, making that letter final. The woman asked them for details of payment. So later, they didn't want to sell to the woman because she has left the business or the company. So the question is that the letter that was sent to the woman, was it an offer or not? That is how can we got this definition. Say that an offer should be final, definite, and leave no significant terms open for further negotiations. So per that letter, you notice very well that everything that needed to be known was there. The mere fact that the lady or the woman asks for mode of payment does not change any significant term in the offer. So that is what amounts to an offer. So please know the definition and then the qualities of a valid offer. Now, any indication which does not have these qualities is not an offer. It is an invitation to treat. So what is an invitation to treat? An invitation to treat is a mere solicit for offer. So someone can make an indication thinking that he is making an offer, but really he is rather inviting another person to come and make an offer. And that thing is what we call an invitation to treat, a solicit to make an offer. Now, what are some examples of invitation to treat? Certain things that do not qualify as an offer. Generally, those things do not qualify as offers. What are they? One of them I can talk about is advertisement. The general rule as established in Partridge versus Crittenden is that advertisements in itself are not offers. So if you see someone advertising his product, he's not offering it to you to come and buy. He's rather inviting you to come and make an offer to buy. So advertisement is an invitation to treat. That is one of them. However, there are two exceptions or two conditions where an advertisement can qualify as an offer. Example is when the advertisement is a unilateral offer or the advertisement is a reward advertisement. So I have a dog and then my dog, I can't find it. So anyone who finds my dog and brings it, I'm going to award the person or reward the person with 100,000 cedis. When that happens, even though it is an advertisement you are making, because of the reward attached to it, it qualifies as an offer. Just like what happened in Carlo versus Carbolic Smoke Ball. Advertisement that is attached with reward or reward advertisement. Such advertisements amount to a particular type of offer called unilateral offers or general offers, an offer made to the general public. Now, such advertisement, the performance of the stipulated act in those advertisements is the acceptance to the advertisement. So if I make advertisement and I say that if anyone finds my dog and returns it to me, I will reward that person. It means anyone who finds a dog and returns it has accepted my offer. But the condition is that for the person to accept my offer, that is the unilateral offer, that person must have been aware of the advertisement. So for instance, you didn't know that I have made advertisement about my missing dog, but you found the dog and you returned it. In that sense, you have not accepted any offer because you are not aware of the offer. Gibson versus Proctor says that before you can accept a unilateral offer, you should have been aware of the offer or of the advertisement. Another exception where advertisement will amount to an offer is when the advertisement has clear terms, definite terms, and explicit terms. Even though you are making an advertisement, but then you made it clearly, expressly, and in a definite form. Such advertisements may qualify as an offer. So for instance, in the case of Lefkowitz versus Great Minneapolis Surplus Store, for instance, the advert stated that first come, first serve. You were selling fair coats. First come, first serve. And then when you come, it will be at a sharply reduced price. These were adverts with specific terms. So once the person comes, you are supposed to do what we have said. Advert with definite and specific terms. They are offers and not mere invitation to treat. So please know the exceptions to an advert not being an offer. All right. The next thing that do not generally qualify as an offer is tender notices. They are notices given out for people to submit their tenders. So for example, I want to celebrate my birthday, for instance, and then I ask event organizers to submit their tenders on how much they are going to spend to organize my birthday for me. That notice that I am giving out is not an offer. It is an invitation to treat, such that the person to whom you are giving that notice is now supposed to come and make an offer for you to accept. So the notice itself does not amount to an offer. However, sometimes, depending on how a tender notice will be given, it may amount to an offer. And mostly they amount to what we call a standing offer. Now, a standing offer is where a person makes an offer that I am going to supply goods anytime you order. Anytime you place an order, I am supposed to supply. That type of offer is called a standing offer. And then anytime the request is made, it is an acceptance of that standing offer. So you look at a case like Great Northern Railway Company Limited versus Wickham. You can also look at the case of Pebi versus Attorney General. It's a Ghanaian case. So that is one other thing that do not qualify as an offer generally, unless under certain circumstances. Tender notices. Another thing that do not qualify as an offer, but it is merely an invitation to treat, is display of goods on shop window or self-service shelves. When I display goods, you come to my shop, I have displayed goods on the shelf. You go to a supermarket, the goods are being displayed there. You go to China Mall, the goods are being displayed there. That kind of demonstration being done over there is not an offer. They are not offering the goods to you. So you look at a case like Fisher versus Bell. The court said that when you see those things indicated there, it doesn't mean that they are offering them to you. You will rather pick the goods and go and make the offer at the counter where they take the money. That is where you will now offer to them that you want to buy this, and then the salesperson over there will accept it. So that is where the contract is concluded. Therefore, the display of the goods itself is not an offer, but then a mere invitation to treat. The same thing happened in the case of Pharmaceutical Society of Great Britain versus Good Cash Chemist. Pharmaceutical Society of Great Britain versus Good Cash Chemist, decided in 1953. Display of goods is not an offer, but then an invitation to treat. Another thing that do not qualify as an offer is auction sales. When auction sales or advertisement of auction sales, or even the putting up of goods to be sold under auction sales is made, that is not an offer. They are not being offered to you. It is an invitation to treat. So you look at Harris versus Nickerson. So it doesn't mean that once you come for the auction sales, the thing is supposed to be sold to you. That is not what it means. It is not an offer. It is an invitation to treat. You are now being invited to come and make an offer as to how much you will pay for the goods. So for instance, when you look at section 4, subsection 1, A and B of the Sale of Goods Act, it affirms this position that when goods are being put up for auction sales, it does not make it an offer. It is not a concluded offer. It is an invitation to treat. Section 4, 1, A and B of the Sale of Goods Act of Ghana, 1962, Act 137. You can look at it. However, auction sales can be with reserve price or without reserve price. Now, reserve price is the minimum price that the auctioneer may indicate that at this point in time, anyone who is coming to make a bid of price should not bid below this price. That price being stated by the auctioneer is called the reserve price. Now, the law is that if the auction sales stated a reserve price, then the auctioneer is not bound to sell the goods to anyone who bids below the reserve price, even if that bid is the highest bona fide bidder or the highest bona fide bid. If it falls below the reserve price, the auctioneer is not supposed to sell, or he's not bound to sell to the person who bids it. Look at McManus versus Fortescue. McManus versus Fortescue. If the auction sales is without reserve price, meaning that the auctioneer did not state any minimum price, then the auctioneer is bound to sell to anyone who gives the highest bid. So the highest bona fide bidder has accepted the offer, irrespective of how low or high the bid was. Once it is without reserve price, the auctioneer is bound to sell, as was noted in Wallow versus Harrison. All these cases I'm mentioning, you can look out for the briefs and read them. So these are some of the things that do not qualify as offers. Now, the next thing I'll look at is that, can an offer be revoked? The law is yes, an offer can be revoked. But the law is that an offer can be revoked any time before acceptance. If you want to revoke an offer, it can be done any time before acceptance. Rutledge versus Grant has clearly indicated this. Even the case of Bayern versus Leo van Tierhoven is one of the cases that affirms this principle that you can revoke an offer provided an acceptance is not communicated. So you look at Rutledge versus Grant, for instance. The defendant had offered to buy the plaintiff's house, and then that offer was opened. But then the plaintiff did not give anything as consideration for that promise. So before he could accept within the limited time, the defendant had revoked the offer. The court was saying that yes, one, you did not give consideration. You know, at common law, the promise to open an offer without consideration is not binding. And two, the revocation was done before acceptance was communicated. Therefore, the revocation is valid. But one thing is that revocation of office can be done through a reliable third party. A reliable third party, just as what happened in Dickinson versus Dodds. If I make an offer to you, and then a reliable agent or third party comes to tell you that I have revoked the offer, it is valid. The test is that the person must be a reliable third party, someone that you and I, you the offeree and me the offeror, you and I know that is reliable. If that person comes to tell you that the offer has been revoked, then it is a proper revocation. Now, if you want to revoke a unilateral offer, today we've learned what a unilateral offer is. A unilateral offer is an offer made to the general public by way of advertisement, but then it comes with rewards attached to it. So if a unilateral offer is made and you want to revoke that unilateral offer, the law is that to revoke a unilateral offer, you must revoke it through the same medium the offer was communicated. So if you communicated it through, say, a newspaper, you would have to use that same newspaper to revoke it. If you communicated it through Adom FM, you should use Adom FM to revoke it. If you communicated it through Facebook or TikTok, you should use that same media to revoke it. That is how revocation is done. And this was noted in the case of Shway versus United States. However, you should know that I told you that for unilateral offers, the acceptance of a unilateral offer is the performance of the stipulated act. So I made a unilateral offer that anyone who is able to bring back my dog will be awarded or will be rewarded with 100 cedis. Now, if a person has started performing that stipulated act, I cannot revoke it because acceptance has begun. That is what Errington and Errington said, the case of Errington versus Errington. If the performance of the stipulated act has begun, then revocation is impossible. These are basic principles you should know when it comes to an offer. So I'll end today's video here. If you have any question, you can put it under the comment section, or you can send it to the numbers running on your screens. Also, there is this book called The Legal Companion. You can see it up there. Get that book. It has questions on offer and acceptance with answers. Questions on offer and acceptance with answers. Once that, when you know how to answer them, you would be able to answer similar questions when they drop in exams. So get this material by contacting the numbers on the screen, and then make sure you go through all the questions and answers we have provided in that material on the topic. Once again, subscribe to the channel, share it to your friends, click on the notification button so that you will be notified for next video. See you in our next episode.
The Legal Pond.